welcome everybody. Okay, so we have the last of the documents that we're going to be going over, and also some orders that the judge has made already on May 9th, I believe it was. Let me give some shout outs. Nana. Hello, hello, hello. Good morning. Good morning, good afternoon, good evening, depending on where you are. Good afternoon, good evening. The real angel girl. Good morning. Nina says, I thought the defense had a cutoff date. We're getting into one of those documents, actually. Good day, good day, good day, TK Sass. And yes, a warm welcome for our beautiful mods. From what I understand, the real angel girl, apparently there has been a ruling in the state of Colorado that says the trials must be live streamed. So I know there was a lot of legal changes in that. So I know the judge had addressed that briefly at the last hearing, and she said that there was going to have to be some alterations done to her ruling on no streaming. So hopefully we get the streams back. I've been watching the record. I haven't seen anything yet. So we've got to keep our fingers crossed, right? Thank you, TK Sass. Yes. Yes, yes, yes. Okay, so let me get this shared so you guys can read along with me if you like. Now, the ones, yeah, it will be. I'm hoping. I'm keeping my fingers crossed. Now, I haven't seen the ruling itself. I'm going to look into it, but oh man, you guys, I've been having some headaches. They got me on these pills to lower my cholesterol because I've lost like 10, 15 pounds. I was 122 and I think I'm down to like 115, and really watching my fat intake and everything and my saturated fats and stuff, and still it didn't do anything. My levels are still high. So they put me on this medication, rosuvastatin. Anyway, it's supposed to lower your cholesterol, but the one side effect is that it gives you major headaches. So, oh my gosh. Hey, Luby Lou, good to see you. Okay, so let's get into it. So what I'm going to do, you guys, is any of these motions, like this is the D11, we've got, let me just see here. I've written it all down. I tried to get so organized today, and guess what? At least everything's working on the stream, right? Cross my fingers, touch wood. We have 1, 2, 3, 4, 5, 6 documents that we didn't get to in the last stream. And we have 2 other ones that have been filed also that were just released into the record. So as I'm going over these motions, if the judge has already made an order on it, I will show you that right after I show you the document. See, like right here, we have the order already on this document, okay? So this is the defenses. Thank you, Nana. I appreciate you. Please, yes, if you haven't subscribed, hit that subscribe, hit the notification bell. Please give the video a like and share it out if you can. It is very much appreciated, as is any super chats, donations of any kind are greatly appreciated. If you'd rather PayPal, there is a link in the description of the video where you can join memberships and use PayPal. It helps because it takes a lot of time and energy to do these things. So, okay, so there she is. How you doing, woman? Okay, so defense's motion 11, motion for notice of the prosecution's intention to introduce any evidence or testimony under CRE 807. Now, this is 4 pages in length. We're not going to read through it all. We're going to just go over the basics of it, of what he's asking for. Mr. Barry Morphew, by and through, I need my glasses on, By and through the undersigned counsel hereby request that this court order the prosecution to provide Mr. Morphew with written notice within 30 days of this court's order of any evidence or testimony it seeks to introduce under CRE 807. It is imperative this notice be filed promptly to allow time to respond and to litigate at the motions hearings. So some of these, all of these motions, I think there was like 32 plus two more, 34, were all brought up at the last hearing just a week or so, 2 weeks ago. And the judge did rule on some of them and set motions hearing dates, which is going to be from July 7th to the 11th, I believe, to hear arguments and rule on the other ones. So further, Mr. Morphew requests that this court rule that no such evidence will be admitted if said notice is not provided. Mr. Morphew further requests this court order that the prosecution's notice is not to be filed in the public court file. So I don't know why he doesn't want this in the court record where we can see it. He's giving some examples here as to hearsay is a statement other than one made by the declarant while testifying at the trial or hearing offered in evidence to prove the truth of the matter asserted. Now, we went over this in, I believe, part 1 of the documents. I'm going to have them both linked. At the end of the video, I will go into my studio and I will link them at the end of this video so you guys can go back and see part 1 and part 2. Hello, Cat H. And Under Your Scars, hello, hello, hello. Good to see you guys. So we know that this hearsay that they're talking about, they don't want anything that Suzanne had recorded, written, text, any phone calls. Nope, they don't want any of that being able to be admitted. They're calling it hearsay because they can't cross-examine her. Well, no, they can't, because you know why? Your client made sure she'd never speak again. So they're saying that 807 contains a residual exception to the hearsay rule. It provides in part a statement not specifically covered by Rule 803 or 804, but having equivalent circumstantial guarantees of trustworthiness is not excluded by the hearsay rule if the court determines A, that the statement is offered as evidence of material fact, or B, the statement is more probative on the point for which it is offered than any other evidence which the proponent can procure through reasonable efforts. Like, they can't put Suzanne on the stand, right? So they're fighting. The Real Angel Girl says it's her own words and they should be allowed in. Well, yes, because he's accused of taking her life, right? So she can't be put on the stand. Now, when you have people that were parties to that conversation, it is classified as hearsay if they comment on what Suzanne said to them, like say in an oral conversation. But in certain cases like this, that evidence can come in. Pretrial notification of intent to introduce the statements under Rule 807. Also, what's going to be interesting, you guys, do you guys remember the conversation between her Suzanne and her daughter Macy, where Macy said, "Mom, just get away from him, get a restraining order, file for divorce, we'll get our own apartment." They don't want that brought in either. And I can guarantee you, Macy is going to be grilled. So they're trying to keep the prosecution from even being able to call Macy because she's going to have some splaining to do, right? Right? I agree, you guys. I agree. I totally agree. Okay. So that's what basically this whole thing is. It's 4 pages. Under these circumstances, a fair opportunity must be interpreted to mean disclosure well in advance of trial, so the defense has an opportunity to investigate and respond, as well as to interpose objections with this court, and so this court has sufficient time to hold necessary evidentiary hearings and issues in the findings. But when we look back over here, where this one here, B, the statement is more probative on the point for which it is offered than any other evidence which the proponent can produce through reasonable efforts. That's the one that the judge, I don't know, should be taking into consideration in that, right? Early notice is required in part because of the way the prosecution has provided discovery in this case. They're upset that the prosecution hasn't babied them and put little sticky notes on everything. Here, this is this, and here's where you can find this, and here's where you can find this. And yes, here's all the phone calls we're going to be using, and here's where you can find each statement in each of these phone calls. That's up to the defense to do. That's part of your job, right? It's almost like they want sticky notes on everything to show them exactly where things are. And that's not the job of the prosecution. The prosecution has to turn over files and say they turn over, a big file, and they can say, okay, part 1, part 2, part 3, part 4, part 5, this is what it includes. Now, if you want to see anything within those parts, go search for it. We've given you a breakdown of where things are that we're going to be using. The fact that the government has provided voluminous discovery does not remedy the notice issue. Well, the thing is, like, they're damned if they do. Like, I mean, I understand what's going on here, and I'm going to try and explain that to you guys. We see a lot of this, like we did in the Brian Koberger case, with all the motions Ann Taylor filed, um, demanding a discovery and blah, 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 right? Well, they gave everything, and anything new that's coming up, they're giving it as they're getting it. And what the defense is saying is like, oh my God, you gave us everything. You know what I mean? What's this? Hold on, we're connecting other channels. What? Are you guys still seeing me? Because I just had a pop-up come up. To activate channels, click here. You guys are connected, right? Because my chat, I just lost my chat on, okay, there we are. Yes, it is. I don't know what just happened there, but I lost connection. My chat lost connection. Is it common to try and silence a victim like this? Yes, because I'm going to tell you why. They're in the process right at the beginning, okay? So what they are trying to do is they are trying to get evidence tossed as much as they can. They are going to try every which way to get evidence tossed. That's their job. Because if they can get a lot of evidence tossed, then they have a better chance at getting their client off. Does it mean that it's going to happen? No. But they can't say Barry Morphew can't come back later and say that his lawyers didn't try. You know what I mean? So, I mean, even though, okay, thank you, you guys. All good on your end? Okay, it just happened in my studio in Restream. So I don't know what the heck is going on with Restream lately, but it's a pain in my butt. Barry has a few lawyers. Beller is one, and he has the female lawyer. I'll show it at the end of this document here. And she represented him for his civil case against, remember when he tried to sue all the cops and everything, and it got tossed out. So he has those two, and I know there's two others. So, okay, so this is what they are trying to do, and they want to know every single thing. Okay, so Jane Fisher Brylson, she is one of his attorneys, and she is one of the ones that worked on both his cases in the past. David Beller is somebody new that was brought on because Iris Eaton is not doing this anymore. I used to feel terrible for the two daughters, but when the two daughters try after 2 years to cremate their mother behind the scenes and go sneaky about it and do it at their father's request, they had 2 years that they could have tried to get their mother's remains and have her have a proper burial, and they didn't do it. And the only time that they finally went to the funeral home to get her remains and try to have her cremated is when um, all the testing and everything came back showing that there was BAM found in her bones, right? And pieces of her missing. And where it showed that that was not where she was initially buried. There was no hair there. There was no decomposition there. There was some of her biking stuff that was thrown on top of her that had no decomposition on them. So obviously, this was not where she was initially kept when she was first taken, her life was first taken. So she had been moved probably more than once, if you want to go according to my readings that I did on this case. So when that happened, there's their evidence. That BAM showing up in her bones is evidence. They're trying to get rid of that evidence by cremating her. It didn't work. So now they got to try other avenues. That is the biggest piece of evidence they have is Suzanne's remains. And the daughters tried to have her cremated 2 years after the fact, and only after the information regarding the ban came out. I don't feel sorry for them anymore at their age, the way they've carried themselves since their mother's death, and the way that they didn't search for her, and the way they're sticking by their father with the evidence that they have against him. And Mallory is the oldest. Shouldn't she be questioning her dad? Like, Dad, if you didn't do this, why are you putting all your money, the properties you own, your business, your vehicles, why are you putting everything under my name? Right? They're not as stupid as they want to try and project that they are. I think they know exactly what's going on. They're not kids anymore. They're both over 20 now. They're not kids anymore, and I believe they know exactly what's going on. So on this one, here's the judge's order. Motion for notice. This is for D11. The motion proposed order attached hereto moot. So which means at this point, it doesn't really matter until other motions are heard. So he's already ruled on that one and said that it is moot. Yes, Mallory has all the assets, all the money. Mallory is in control. Mallory was Daddy's girl. Mallory's the one that didn't have a problem shooting and killing animals and whatnot. Like, oh my gosh. I'll never forget them both. Thank God. When the last case was dismissed without prejudice. It's just like the way that they acted and going on these trips and dancing it up. Your mother's missing. Anyway, that's neither here nor there. I can go all afternoon on that stuff. And I also noticed, you guys, that my brother did pop in on the last live stream. So Kurt was here. He did come in right at the end. And Martin did message me over on X saying that he got the message only that evening. So if one of them see that we're on, I'm sure that they will pop in. If you guys see my brother or Martin come in, put big stop signs in the chat so I can see it, because I'm looking at a totally different screen. Okay, and I'm going to do this. There you go, you guys. There is Martin. Just as I said it. Congratulations, Strawberry Wine, Carly with Annie, Rose, Little G, Sandra Moore, He's doing okay. Real angel girl. Let me see. Where's Martin? There he is. Do you want to come up, Martin? Let me know if you want to come up and I'll put the link in for you. There is Martin. His ears must have been ringing. Let me just put it up. Let me just put it up here. You're very welcome. So there is the link, Martin, if you want to come up. Ashley Kane says, sorry, late here, going back to the start. Thanks, Willow. You're very welcome, Ashley. Okay, so we seen the order. The judge said that was mute. Let's get rid of those two. Everybody's saying hello to Martin. Okay, Modish. Okay, give me 2 seconds, guys. I just got to go and grab my earphones because we've got Martin coming up. Hang on a sec. Let me just get Martin on. Okay, I'm going to have to turn off my sound.
Hello?
There he is. Okay, just give me 2 seconds, you guys. Let me go and grab my earbuds. All right. How's that?
Can you hear me?
Yep, I can hear you.
Perfect.
Okay, let me just... I was turning my volume down.
We have a bit of a thunderstorm here.
Ah, okay.
So hopefully.
Okay, so we're on the second document here.
Mm-hmm.
I was just explaining to them, you just came in, so I'm going to explain. We just went over defense motion 11, and it was mute. That was about trying to keep out the hearsay statements. So the judge ruled on that and said it was mute, basically that there's other motions that are going to be coming out that's going to deal with that, so it's moot. So now we're on the D13 motion, and the judge also has ruled on this one, so we're going to go over it. This is a motion for notice and opportunity to respond prior to any consumptive testing. And this is the one, Martin, that I found to be really interesting because Barry, by and through counsel, moves this court to require notice and opportunity to respond prior to any consumptive testing. Well, it's funny that he files this motion, and this is filed April 13th after he tried to have Suzanne cremated. Yeah. So now he's all worried about them doing any consumptive testing. And if you guys in the chat here that if you don't understand what consumptive testing is, it means that if the prosecution does certain tests on evidence, it's going to consume the whole sample.
Yes.
So he is saying that he wants the court to require notice from the prosecution to the defense before they do any consumptive testing. And it's like, well, did you give that same opportunity to the prosecution before you tried to have her cremated?
Yeah.
Did you give them a heads up? You know, I mean, this basically is law. They have to do that. If they like, that's in the rules. If you're going to do any consumptive testing, you have to give the other side notice before it's done. And if there's an argument about it, then the judge has to make a ruling on it. But generally, what they do, if they have to use all the sample, is the prosecution will usually say, send somebody from your defense team and they can be present as well as us during the testing so you guys can see how everything is being done, or if there's something else you want done with the test or whatever, right? But I just found this really shocking for him to even file, considering he tried to have her cremated a couple months ago, which would have consumed all of her remains. You know what I mean? There would be nothing for
Not
testing.
100%.
So yeah, the nerve, yes. I'm telling you, this is the defense objects to any consumptive testing and moves the court to order the prosecution provide defense counsel notice and opportunity to respond prior to the performance of any consumptive testing. And it's like, if I couldn't be in the courtroom, you know what I mean? It would be like, well, whoa, wait a minute.
Red rag.
Didn't you try to cremate her a couple months ago? You have your nerve coming in here now, demanding. I mean, it is rule. But to make a motion for this, you know what I mean? I could just see somebody in the prosecution's office getting this motion and reading over it, and it's like, what? So, and this is what I mean, you guys. They have to try everything to get him off because he's good. As far as I'm concerned, and in my opinion, he's guilty as F, and he's going
Yeah.
to be found guilty, and he's going to spend the rest of his life in jail. And they're trying everything, including trying to have her cremated behind the prosecution's back, which is destruction of evidence. Would it
Yeah.
not be? I wonder what would have happened there
Oh, yeah. That would
if
be.
he would have been able to go through with the cremation if it hadn't been stopped just in time.
Yeah.
I wonder what would have happened. Isn't that destroying evidence?
Yeah. Oh, 100%. Yeah. It destroyed the evidence. And then turn around and say, well, we can't we can't do the test. Do you know what I mean?
And yes, and you know what? You just brought that up, and which is good, is because they had motions already filed to be able to get the remains to do their own testing.
Yeah.
And that motion hasn't been heard yet,
That's right.
right?
That's right. Yeah. It was
But
supposed
they
to be
tried to
later.
cremate her after they filed the motion saying, okay, well, we need the judge to make this order so we can get some of the remains so we can do our own testing. And then a couple of weeks later, they try to cremate her.
Was that back in March, I think, actually? At the end of March. Was that-
Yeah,
Yeah.
a couple months
Yeah,
ago.
yeah, that's right.
So it's like, what the actual F?
Yeah.
So, and I just explained this to you. Consumptive test is one which prevents further independent testing of an object being examined. Usually it's when evidence seized in so small a quantity or unstable condition that qualitative laboratory testing will not leave a sufficient quantity of the evidence for independent analysis by the defendant's experts. So this is just basically him saying, you guys can't do any testing. We want, maybe our own experts to go over it, the testing of blood, bodily fluids, tissue, organs, hair. Well, no,
None of
wait a
them.
minute. You want to talk about the hair, Martin? Tell them about the hair.
No. There's no hair. Do you know?
Right. There was no hair.
No hair at
Like,
all.
For them to even put this in here, knowing that when they did the autopsy, when they found her, there was no hair. Her hair wasn't there. Neither were her feet.
Hands.
Neither was any tissue. I don't think there was even any organs.
No, there was nothing.
It was just
there was
bones.
there was no sign of any decomp whatsoever.
Right.
Or other clothing.
Yep. And they said, or other physical evidence may necessarily be consumptive and destructive of some critical evidence. Right. That's critical evidence that you tried to cremate.
But I would say the sample that they would use would be very small. Do you know what I mean?
Mm,
And it's probably heated then. You see, up to a certain temperature to release gases, and that's how they get the. I'm only guessing, but if they're going to destroy it, I'd imagine that's what happens. Do you know what I mean?
mm, yeah. But I mean, they have her bones,
I have roughly,
minus her feet and a couple fingers. I think weren't there either.
yeah.
And her hair was missing. There's no organs. There was no tissue.
But there was no organs or anything like that. But they did have her port. Do you know what I mean?
Yeah.
Like that body was meant that those remains were meant to be found.
You think so?
100%. 100% they were meant to be found.
Yeah, because I'm assuming they would have gotten rid of the port.
Shallow grave, a guy who digs holes for a living,
Mm,
shallow grave, probably buried when there was no pressure on. Do you know what I mean?
yep. Yep.
Uh, he could have, like, this guy travels all over, mountains or whatever, and he puts her in a place where there's a hunting trailer there, and the the guy that was sleeping in that trailer,
Was
uh,
the trailer still there though when she was found? I
yeah,
don't remember.
oh, the trailer was there, yeah, yeah. It's not there now, I don't think.
And it's funny because, well, not funny. I should wrong. Don't take that literally. Um, just I think it was like 6 months after she had gone missing and everything. We had gone on a little road trip, like online on Google Earth,
Yes,
and we started going through all those places. We went down that road where she was found, and I said, you know what? I says that tree is sticking out for a reason. That would be a
hmm,
place where he would bury her because when you go, there's nothing. Like you go past a bunch of houses,
yeah,
and then when you're going down this road, there is nothing. It's just flat on
two
one
miles,
side, and on the other side, it's like flat, 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 right up to
yeah,
the base of the mountain. And I said, now that would be a monument so he could remember where he buried her.
yeah,
And then 2 years later, that's where she's found.
yeah.
That tree always stuck out to me, and it's weird.
And that tree was in that little compound where the trailers were parked and whatever.
Yeah.
Yeah,
So anyway, that's what this one is all about, and this is defense 13. The judge hasn't ruled on this yet, and I hope when the judge does rule on this, the prosecution gets up and says, you know, we just want it on the record, Your Honor, that they did try and cremate her 2 months ago, you know, and
yeah,
now they're worried about us doing consumptive testing
yeah.
when they tried to destroy evidence. Like, and I don't know why they weren't charged with that because
Oh,
they knew her remains were the biggest evidence that the prosecution had
this
because
is
it showed the
backfired.
dam.
This is backfired, and this is just another feather in their cap. Do you know what I mean?
Hmm. Yep. Yep. Okay. So let's get rid of. Oh, he did make an order on this one. It's granted. So this is on the D13 order, what we just went over here, D13. So the judge did order that the prosecution is going to have to give notice to the defense before they do any consumptive testing,
They probably
which
would
we do.
anyway. Do you know what I mean?
Yeah,
It's all these a lot of these motions are, you know, they're silly because these are the type of motions that most people would make. Do you know what I mean? And
right.
you would get replies to. You know what I mean?
These are motions. A lot of these are motions
Common
basically
sense.
that are common sense and discussed outside of even court
Yes.
and is stipulated to.
Hmm.
There's no reason for a hearing on it. Like
No.
it's, and this again is like I said with Ann Taylor in the Brian Koberger case, they're just dumping everything they can on the prosecution to gain a little bit more time.
Yeah, time and trying to keep the prosecution busy as
Hmm.
well, maybe.
Yeah,
Do you know what I
they're
mean? And
trying to bury them in
trying to
paperwork because,
try. It worked before. Do you know, they buried them
right?
in
Yep.
paperwork, and then they, when they couldn't cope with the paperwork, next thing you knew there was sanctions against them. You know, so
But to see the big difference this time is they had all their ducks in a row.
oh
They
yeah,
had everything ready except for a few things that still hadn't came back yet, which is normal in any case. Um, they had everything ready to go. Here you are. He's been arrested, he's been indicted. Here's all our discovery. You don't even have to file a motion. We want discovery. Nope, because here it all is. Now we have this, and this. Still, we're still waiting for that to come in. As soon as it comes in, we'll hand it over to you. Like they had their ducks in a row. So that's the big difference between the first time they tried to go to trial with them and this time. And Linda Stanley was all over the place. Even the law enforcement was saying, we're not ready yet. And she still went ahead and had him arrested long before the case was even ready for him to be arrested. And then they tried to, it was a constant trying to catch up. That's what I found with the first trial.
Hmm.
So this one here, D14, again, these are all from the defense. When you see the D, that means it's the defense. Motion for discovery, impeaching information. Mr. Barry Morphew, by and through his counsel, moves his court to order the production of any impeaching and exculpatory evidence and to order the prosecution to make an inquiry with the witnesses and police agencies involved in this case, including those in Chaffee County, Fremont County, the FBI, Colorado Bureau of Investigation, and any other agencies involved in the investigation in this case, as well as other sources available to the prosecution to discover and disclose this information in support, Mr. Morphew states. So it's like, again, wanting the prosecution to do the
well, that's what they have.
defense's job,
But they have to. The prosecution have to release the discovery. Do you know what I
right?
mean? And
And I believe they have, but I think that the defense is saying, come on, there's got to be something. There's got to be something. We want you to go back now. We've got your discovery.
now
Both,
there's probably some bits that are late. Do you know what I mean?
right.
They're not in trouble for not having them uh, given over, but they'll be the last bits they'll want to hang just before they cut off. Do you understand me?
Yeah, but what I'm saying here for impeaching information, it's almost like somebody else had to have said something to, like, this is what the defense is got in their heads. Because see, I worked for a lot of criminal defense attorneys, so I get what he's trying to do here. It's like, okay, well, we've got your discovery and we see what you have given and what this one said and that one said and this one said and that one said. We want you to go back to them now or go back through their interviews or their notes or whatever and just see, make sure there's nothing exculpatory in there. Well, if I've given you everything, that includes any notes, any interviews, everything regarding said person.
Yeah,
But to me, it's like we want you to go back and look over it again, any other agency involved, and make sure that you've disclosed every piece of information that you have regarding said person. You know what I mean?
yeah.
But
You've seen
like I said,
trials. You've seen trials where discoveries come in after the trial has started.
yeah, and it's problematic in a
Yeah,
lot of ways because you really
depending on the
risk,
judge.
yeah, depending on the judge, you really risk having that not
Yeah,
admissible, unless it's something like extraordinary that until that point couldn't be discovered by anybody. Like all of a
yes,
sudden, somebody pops up and says, "Okay, look it, I was there with them and I helped them."
yeah.
You had no way of knowing that before. So
Mhm.
something like that would automatically, yes, they would be able to get that admitted. But I mean, if there's stuff that, oh shit, this was in the file and I totally forgot, like, well, you're not using it now. You didn't disclose it. You're not using it unless it's exculpatory. And as long as whatever's in there, those issues haven't arisen yet, it's problematic. It's problematic for both sides. Um, the real Angel Girl says, is the trial set for October? Yes, this October. So the use of discovery material for a defendant's impeachment purposes at trial implicates the due process and confrontation rights of the accused under the Colorado State Constitution and the U.S. Constitution. Um, Reversing convictions where prosecution failed to comply with a discovery order requiring disclosure of witnesses by providing a list of 72 witness names just 18 days before trial. So they're going over other cases. The prosecution also has a duty to provide discovery of any material that may be meaningful to the defense, regardless of whether it's exculpatory or will relate to testimony the prosecution intends to present at trial. I believe that they've already given all that. If the prosecution refuses to provide Mr. Morphew with material evidence which is favorable to the accused and relates to either the guilt or punishment of the accused, prosecutor violates their ethical duty and due process is denied. See, and this is what I'm saying.
Yeah,
They're trying to imply that the prosecution's withholding something,
yeah.
or you go back over it just in case. I don't care if you've gone over it 10 times, go over it one more time and make sure. And we want you to do this. We want the judge to order you to do this. You know what I
You only
mean?
have to look at the trial one, before, the preparation,
Yeah.
and it was the same thing. All these motions,
Yep.
and they were on their case. You know what I mean? They were making them jumping through hoops,
Hmm.
and this is the
But
same thing.
this is normal.
Yeah,
A lot, even though it's aggravating and
this
it's
is
time
normal.
consuming, this in a high profile case like this one is, and you've seen it in Brian Koberger, we're seeing it in the Luigi Mangione one. All these high profile cases, you're going to see this. Well, look at even Ann Taylor. She tried to go back to 1800s law, you know,
Yeah,
and what the forefathers intended for this. And that's not the way we're doing it now. And we should be doing it the way the forefathers intended. And it's like it's throwing shit at the wall. Um, and a lot of this is doing exactly what I said. They're just trying to bury the prosecution in paperwork, hoping they make a mistake, and then they can jump on it.
but they've got very little. You see,
What's that?
they've the defense have very little. Do you know?
Right.
Their hand has been shown,
Hmm.
and the BAM is just,
The
that
icing on the cake.
that's so hard. Do you know what I mean?
Yeah.
I don't know how they're gonna get around that one, but
Especially when you got a cap for the BAM in the dryer with the shorts he was wearing that day,
yeah,
you know? Um, and just some of his interviews where, he didn't disclose things. Oh, yeah, 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 I forgot about that. Oh, yeah, yeah. Well, no, you didn't forget about it. And that's the one thing when law enforcement comes to question you, they don't ask you a question that they don't already have the answer for.
most of the time.
Hopefully, other things that they don't know about slip out, but if
Yeah.
they're asking you a question, they already know the answer.
Well, most of the time. I wouldn't say all the time, but most of the time.
Well, I'd say 99%. Like, when they're directly asking, interrogating somebody they suspect, the questions they're gonna ask, how can I say this? They're gonna ask specific questions that they already have the answer for in the hopes that because it's hard against them. It's something that they can't get out of. They're hoping that they go off on a tangent and bring something else up that
Well,
they don't
there's
have
one guy
answers
that went
for.
off on tangents for sure.
Hmm. So
No
it's
big
like
matter.
in the moment when you're being accused of something and you're trying to deny it, but you know you did it, you're going to try and change the subject. You're going to go off on a tangent. And it's those tangents, and you let them talk because they're going to start spurting out things that you didn't know about. And
Yeah,
now you got more shit to look into. And
that's a
they're
fact.
trying to distract against the question that you asked them. You know what I mean? Because they know they did it, or they know that they lied about, they gave a false answer to that question, and they're trying to deflect from it. You know what I mean?
Well, it always seems to have a little bit of truth
In every lie, there's a little
in
bit of
every
truth.
lie. There's a
Yep.
little bit of truth in there. That's what I've noticed
Yep.
anyway.
So I'm just going to scroll through this because that's what they're asking for. Anything. Make sure, go back through your files and make sure that you have given us everything. Because if not, it's bias, it's this, it's that. We can sanction you. All this, well, the prosecution already knows about sanctions. I don't think they're going to make the same mistake twice. So,
Let's hope not.
no. So we'll get to the end here. I scrolled through it just because some people like to go back and just read through the whole thing so they can pause it and read through. So I always scroll through the document. Wherefore, Mr. Morphew respectfully moves this court to order the prosecution to produce all impeaching and exculpatory evidence and to require the prosecution to make a diligent inquiry of all agencies involved in the investigation, which means go back and make sure that they've given you everything, right? Including Chaffee County, Fremont County, FBI, CBI, for all such material and to order its immediate and continuing disclosure to the defense. So it's like, why didn't you just call them and say, look we think that there's some things missing here, maybe with TBI or CBI or whatever, FBI. Can you just go and check with them again to make sure they give us everything? Because maybe from the last trial we see that there's this and we don't have that. Can you just go and make sure instead of doing a motion for it, right? This is other things that can also be agreed upon behind the scenes, and they want to make the motion on it. They want it on record, and this is all going to be on record for appeal, for no other purpose but appeal. Okay, so the next one. Do you have anything else to add about that one, Martin?
No, no.
Okay, so D18, request for in-person trial testimony of laboratory employees and technicians pursuant to CRS 163309. Now, in the last set of documents that we went through, the prosecution had asked for certain people from the laboratory to testify
Decipher.
via Zoom, right?
Hmm.
Or whatever system they use.
Was it like a board here? Was it?
No. It was for in-person trial testimony that I think there was two people from the lab that were going to, because of vacationing or something like that, they were going to have a hard time
All right.
getting
Okay.
away to come to Colorado
Yeah.
for the trial.
Okay.
So the prosecution had asked the judge to, or maybe even ask the defense, look at, would you agree, stipulate to these two testifying via Zoom? And I guess here's their answer. The defense is saying no. Defendant Barry Morphew provides this written notice pursuant to section 163309, asserting his constitutional and statutory rights to confrontation. So this whole document, it's 2 pages, and basically what he is saying is, no, we want them here in person,
Well, he's got the right to face his
accusers.
accusers. You know what I mean?
So that's it here. Asserting his constitutional and statutory rights to confrontation. Mr. Morphew will object to the admission of any laboratory test results or information through the use of testimonial hearsay evidence, including but not limited to laboratory reports and surrogate witnesses who did not participate in the testing. So don't send anybody else, and we're not doing this over Zoom either. So Mr. Morphew requests that the prosecution produce for in-person trial testimony the employee or technician who personally accomplished or produced any analysis, comparison, identification, or any other criminalistics or scientific laboratory results the prosecution seeks to introduce. So when you're doing this much testing, you could have 15 different lab personnel working on different parts of this.
Mm.
There's one that does extracting. There's one that does this. There's one that does that. There's one that, you know what I mean? One piece of evidence, there could be 4 or 5 different people
Yeah.
that do the different stages of testing for that piece of evidence. He wants each and every one of them hauled into trial. Don't send just one and say, this is what our lab did. We want each and every individual and we want them here in person.
Mm.
Yeah. So that's D18, and the judge did make an order. The prosecution is on notice of the defendant's demand. He ordered it. So each and every one of these lab technicians, they could empty out a whole lab.
Yeah.
You know what I mean? Like, what if there's 20 people that work in this lab and 10 of them were involved in this testing, or 15 of them, depending on which piece of evidence, and out of 20 of them, 15 have got to come to Colorado to testify. And now they're left with 5 people in the lab. There's no way a lab can function. You know what I mean? But
Mm.
he has a right to face his
Yeah.
accusers. But it's just odd. You don't see this often where
No.
the defense really goes hard and says, no, I don't care if this person just did this, putting it onto a slide, they better be here in person. I don't care if this person just gave a second opinion on it, like looked at something through a slide and gave a second opinion. Nope, each and every one of them are to be here. If you're going to use that slide, we want everybody who was involved or came in proximity of that slide, we want them here. It's just
Now,
ridiculous.
you see, this becomes an issue then when, like, I'm not sure exactly how many witnesses they're going to be allowed.
There was quite a few. We went through the witness list for the
Like,
prosecution, didn't we?
like there's over 100, if I remember rightly, of law enforcement alone on the witness list.
Well, this one here, they're just talking about the laboratory employees and
Yeah,
technicians.
I know, but
There had to have been a good 30, 40 lab technicians or lab employees.
yeah, well, I would have counted them in with law enforcement. You know what I mean? The anyone that had anything to do with the FBI or CBI. Um, but do you know how long is this trial going to go on? Then, if you have, do you know what I mean, days of just a witness coming in for 15 minutes, do you know,
Mhm.
just I can't see all that happening.
I don't know. I don't know, but right now they've got it scheduled for what, 3 months?
Yeah,
I'm going to be tired. I'm going to be so tired. I'm going to be so fed up, especially if we can live stream it. I'm going to be so fed up seeing his face.
yeah, yeah. I'm looking forward to it because
I'm looking forward to it because
yeah,
I want this son of a bitch to spend the rest of his life in prison,
yeah.
because I feel he's guilty. So, I mean, to each their own. Everybody's entitled to their own opinion, but I feel he's guilty. And it's like, I don't know. Okay, let's get rid of this one. So, they have to all be there in person. Which one is this? This is 19. Motion to require the prosecution to provide a good faith witness list with order of witnesses. So there we go, right there. Mr. Barry Morphew, by and through his attorneys, hereby requests this court to require the prosecution to provide a good faith witness list. So what they're saying is the prosecution has endorsed 241 witnesses, and they're saying, because they've got to speak with each and every one of these 241 witnesses, the defense has a right to speak to them, right?
Mhm.
And so basically, what the defense is trying to say here is, by saying it this way, a good faith witness list. In other words, we know you've put a whole bunch of people on this witness list that you have no intention of calling.
Mhm.
And you're going to force us to interview 241 witnesses, and maybe 100 of those you're not going to call, and we're going to waste our time. That's basically what they're saying.
Tough.
No later than 45 days before trial, setting forth those witnesses the prosecution intends to call at trial and the order of the witnesses in support, Mr. Murphy states. Well, I think it's 30 days before trial. They have to give the court and the defense the list, like the order in which they're planning on calling their witnesses, so the defense can set up what the questions and everything that they're going to be asking these people so they can prepare, right? The current number of endorsed witnesses exceeds a number that can realistically be called to testify at the upcoming trial for which 6 weeks has been set aside. 6 weeks? I thought it was longer than that. And do you see where I have a problem with this one, with number 2, Martin?
Let me enlarge it 1 second.
It says the current number of endorsed witnesses exceeds a number that can be realistically be called to testify at the upcoming trial for which 6 weeks has been set aside. Do you see where I have a problem with that?
Sorry, can you just repeat that again? Sorry.
The current number of endorsed witnesses exceeds a number that can be realistically be called to testify at an upcoming trial for which 6 weeks has been set aside.
Yeah.
So, in other words, they're saying,
Oh,
we've
same for
got 6 weeks of a trial here, and 241 witnesses
Yeah.
realistically cannot be called within 6 weeks. We want a good faith witnesses. I have a problem with them putting that in there because you son of bitches are the ones that are calling in demanding that every single
Yes.
person in that lab be called
Yeah.
when they could have brought 2 people instead of 30,
Yeah.
40, 50.
Yeah. You would just bring in the senior people, and 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 you would have
Right,
affidavits from the other people. You know what I mean, or
right,
whatever.
right. That's how it's generally done. But you can't, in one motion, demand that each and every one of those lab personnel that you mentioned are brought in. Anyone who touched any or did any results and touched any of the evidence, we want them here in person. And then in your next motion, you're complaining about witnesses exceeds a number that can be realistically be called. But you added to that problem. You added to that problem by demanding 30 people be called in instead of maybe 2 or 3.
Yeah.
A good faith list of witnesses that the prosecution intends to call should be tendered to the defense. More importantly, the prosecution should be required to carve its list of witnesses down to coincide with fairness. But you are forcing them to add more witnesses, and then you want them to cut back on other witnesses. So, in other words, they're trying to have the judge make a ruling like, okay, look, we got to limit the witnesses here. So, if you want all this lab stuff in, there goes 50 of your witnesses that you're allotted. So, you're going to have to cut some out from other parts of what you wanted in the trial. You see what they're trying to do here?
Yeah.
Right?
Oh, they're playing the. They're
Playing the
not. They're
game.
not playing. They're playing the game big time.
But I mean, you can't limit prosecution witnesses. It's on the burden is on the prosecution to prove their case. And if they need 150 witnesses to do that,
Yeah.
then they need 150 witnesses to do that. Now, if you want to add another 50 to that mix, don't come back in your next motion and complain that we got too many witnesses on our witness list. You're forcing our hand.
Yeah.
And then ask the judge to cut down how many witnesses we can have because you're forcing us to have 30 or 40 more than what we intended to call.
It's a great argument, actually. That's a great argument.
But you see how they're playing? Like they've
Yeah.
showed their hand at what they're willing to go to and what extent.
The last time we spoke, there was 2 new witnesses that were added. Do you remember that?
Yeah.
Yeah, and I said I remembered the name. I did. I
I
did know.
forget who they were though.
Well, one was Rebecca Hauser,
Oh,
who,
yes, yes.
she was the one that the house on the beach side.
Yeah.
She was the designer, construction designer, and the other one was
Wasn't the other one the property that butted up
that where the cameras were
Yeah.
at DSI,
Mm-hmm.
um, and her name had come up before with me, and I actually had her when I looked at my map, my Google Maps. Her name came up. Um, Veltri is her surname. Her
Oh.
name came up very close to DSI again, but across the street behind the houses, up towards where Suzanne did her biking, and
Oh.
and I just thought it was interesting that she was on the witness list.
Hmm. So Nana says the defense is thinking way ahead, cause jury to lose interest by having 20 people testify on lab instead of one. Yeah. Um, but they're not thinking ahead because they're trying to get certain things thrown out. They're trying to manipulate the system to work better in their favor because there's just too much against Barry right now. So they're trying to manipulate things. So if they're forced, if the judge says, okay, well, that's granted, you're going to have to bring in each and every person from the lab that had any dealings with any of the evidence. And so, which means you're going to have to drop some of your witnesses because there's just too many or whatever. I don't know what they think is going to happen, but as far as I'm concerned, you're not going to be able to limit the prosecution's witnesses um, because they have the burden to prove he did this. But on the same aspect, if they're forced, like Nana just said, if they're forced to bring each and every one of them in, the jury's going to get tired of hearing about it. So they're hoping maybe the jury will get lost in the information. I don't know. Get bored of it, get a little upset with the prosecution because they're going over the same things over and over and over again with just different people. I don't know. But these are some of the tactics that defense attorneys use within the law. Remember, you guys, I told you when I was working for in the criminal law offices that I worked in, we knew where the line was and we'd come just below that line, sometimes right to the line. We never crossed it, but we came damn close to crossing it. We know where to push and we know what we can do to mess with the prosecution. So, what happened to Lyra Seaton? She's no longer, I don't think she's a criminal lawyer anymore, is she?
I'm not too sure actually.
I I read an article on her and I forget. I thought she'd left the firm and whatever, but
Yeah, I did hear a few things like that.
mhm.
Um,
She made a lot of money on the Barry Morphew case,
oh,
believe
she did, and I wish she was there now
me. Right?
because I just wish she was. Yeah.
Okay, so that's what basically this one is going over. Wherefore, Mr. Murphy.
Judge
Oh,
Murphy.
God. Mr. Morphew respectfully requests that this court requires that the prosecution tender good faith witness list containing those witnesses they intend to call at trial and in the order of presentation. So that's that one. We've got a few more here. Do we have, okay, order the last two here. This is their motion and the judge made a ruling on it. So we got two more to get through before then. This one, I'm doing this with a major headache. This medication they got me on to lower my cholesterol is giving me major headaches. So even looking at the screen, I got my sunglasses on, looking at the good. Thank God you guys can't see me. Sitting here with my head, I couldn't find my earbuds, so I got a headset on, earphones, these big Sony earphones. I've got my sunglasses on in front of the computer. Oh gosh, I'm a mess. Okay, D22, motion for court order requiring the prosecution to respond to all defense motions in writing. Isn't that how it's usually done?
Hmm.
The defense files a motion, the prosecution files their response. Then the defense usually goes back and it usually goes back and forth under the same motion because it'll be D22 prosecution's response. And then it'd be D22 defense's response to the prosecution's response to the motion. And then it'll be the prosecution's response to the defense's response to the prosecution's motion to the motion. It's just crazy.
Then they
That
might have
it
an appeal.
is it's just crazy. Barry Morphew, by and through his counsel, respectfully requests an order requiring the prosecution to respond in writing to all defense motions. In support, Mr. Morphew states, for the defense and the court to adequately prepare for the motions hearing in this case, it is imperative that the defense and the court have adequate notice of the prosecution's motion on defense motions. Well, that's how it usually works. Unless the prosecution specifies the grounds for their position and their legal authority in writing prior to the motion's hearing, it will be impossible for the defense to adequately prepare for the hearing, to have fair opportunity to be heard, and to preserve issues for potential further review. I don't get that. Because in every case I've ever worked on, and that's in Canada, or that I've seen in the US, when the defense files a motion and it's put into the record, then the prosecution puts their response into the record.
Yeah.
So I don't know why they are, like I said, some of this is just burying them in paperwork. Furthermore, it's a colossal waste of time and judicial economy to prepare for litigation at a motions hearing where the prosecution not to oppose the relief sought. You want to talk about a colossal waste of time? Some of these motions just fit right in there. The fundamental role of a response is to give this court, Mr. Morphew, notice of the prosecution's position concerning the facts and law so that the issues can be narrowed and defined, and Mr. Morphew can prepare a defense or a response. I mean, this is just law 101. You know, if a motion's filed, you file a response. It's in any case, criminal, civil, family, any case. That's why they have to have a judge order it like he's babysitting the prosecution. I don't know, but they seem to feel that they need a court order to force the prosecution to respond and put it in the record. I don't know. It just seems off to me. Mr. Morphew requests his court to order that the prosecution must respond to all defense motions in writing within no more than 14 days and not less than 7 days prior to any hearings, whichever is longer. And if they fail to do so, this court should deem the defense motion confessed. Oh, okay. So you're going to nail them with 32 motions and you want answers to all of them within 14 days and not less than 7 days prior to the hearing. But these are motions that you guys have probably spent a month doing.
And hanging on to and send them all at once.
Yeah, and sending them all at once to bury them in paperwork, which I've stated since the beginning.
This is what they're doing in the first trial, in the prelims, in the...
So D26, a motion for discovery and ongoing full disclosure of any records, materials, or investigation of prospective jurors. Barry Morphew, through undersigned counsel, moves this court. I haven't read through these prior, or I would have just highlighted parts. So I'm reading them for the first time too, and trying to absorb it and then comment and give a little easier, because some people in the chat don't understand a lot of the legal jargon. So yeah, I got to think quick on the spot. Barry Morphew, through undersigned counsel, moves this court to require that the prosecution provide to the defense counsel any materials, reports, notebooks, or other information regarding prospective jurors that the prosecution has obtained or will obtain, including but not limited to criminal histories, record of service for either voir dire or service on a sitting jury, relationships or acquaintances with members of the prosecutorial team, prosecutorial officers, or those of the prosecutor's agents, whether on a social, professional, or other. I mean, this is normal. I don't know why they are requesting an order from a judge to do what is legally required for them to do. You know what I mean?
Yeah.
This is a legal requirement. So
that's why I see with a lot of the motions that they're just mundane, average stuff. It's it's just you expect that's the way it would run. You know what I mean?
Right. So, like, say somebody got a jury notice and they're a convicted felon,
Mm.
and they put on their jury questionnaire that's mailed to your home, and you fill it out and you send it back in, right? Excuse me. And if you're a convicted felon, you got to pay. I'm a convicted felon. I would, and the reasons and your sentence and everything in there. Any other convictions, anything like that. That's all on the jury questionnaire. And I don't know. I don't get this. I don't. And if the prosecution has any kind of good or bad juror lists, previously served lists, or the equivalent, that would be the jury commissioner's office. Now, I don't know if the prosecution would have copies of the jury commissioner's lists. I don't know. Do they keep good or bad juror lists and previously served lists? I don't
I've no
know.
idea. No idea.
I've never come across that before. It's something like this. Prosecutors and their staff and agents, and many of the investigators and others associated with the prosecution teams have longstanding ties with the Alameda County community and the broader community in this judicial district. So they want to know if any of them are related to any of the. Well, does this mean that the jury questionnaires have already gone out?
I don't think so.
Yeah, because I haven't seen, unless it's something that they're hiding from us, I haven't seen anything in the record that says the jury questionnaires have been sent out yet. So you wouldn't know this. You wouldn't know if you're related to anybody that is going to be called for jury duty, and yet they still have a previous motion that deals with jurors, and that they want copies of everything, and they want the court to decide what jurors should be released after reading their questionnaires, and not the jury commissioner's office. This is just not making sense. So not only now do they want the judge to do the jury commissioner's job, they also want any lists of some kind, whether they exist or not, that the prosecution has. I don't think the prosecution would, if there is such things, I don't think the prosecution would have that. I think it would be the jury commissioner that you want to axe out of all of this and have the judge decide who stays and who just goes as a potential juror for voir dire. You know what I mean? It's not making
Yeah.
any sense. Like, there's agencies that are there for reasons. The jury commissioner is the one who goes through all the questionnaires, and
Yeah.
anybody with felonies or stuff like that, or knows somebody on the prosecution, or knows somebody on the defense, or knows the defendant, or the daughters of the defendant, or whatever, those are weeded out before you're sent the jury pool for voir dire.
Yeah.
But he doesn't want the jury commissioner to do that. He wants a judge to do it.
It's crazy, isn't it?
This is just like,
Well, it's not Barry. This is obviously Jane, I'd say.
and Beller, the two of them.
Yeah, probably more Jane than Bella, I'd say.
Yeah,
If you
because
look
this kind of falls in line with how she's acted in the past.
in the lawsuit, civil
Yeah.
lawsuit, when you see how that was put together,
Mm,
like it was, if I remember rightly, it was 300 and something pages,
yeah.
and it could have easily been reduced down to a quarter of that. They
Yeah.
kept repeating,
Hmm.
like it was copy and paste all the way through it.
Yeah.
So it's just a lot of reading through it. It's just volumes.
See, they don't even know here. Like, the Colorado Supreme Court has ruled that the state has no special right to the results of its investigation of prospective jurors, and that defense attorneys are entitled to obtain this type of information from the prosecution in accordance with Colorado Criminal Procedure Rule 16C, if such information is in the possession of the prosecution. this stuff would be in the possession of the jury commissioner's office. So they're saying, well, if you've got inside information, we want to know about it too. Oh God.
It says a lot that they're of what they're doing here. This
Mm-hmm.
tells me they're struggling big time.
They are.
Like they're looking to try and a bit like the first one. They're just trying to overwhelm as much as they can. But
Yeah.
I'd imagine now the prosecution have a big team. Do you know what I mean?
I this prosecution team seems to be on the ball with everything.
Yeah.
So I'm not concerned about it. They can keep trying all this stuff, but I don't see how any of it's going to fly. Bad juror lists and the prosecutor's duty to disclose. Robbins accurately places Colorado on the list of states that provide for full disclosure and urges other states to follow suit about this bad juror list. But I don't think that's if the prosecution has that, but I think that would be something that the jury commissioner's office would have. Now, if the prosecutor never asks for that, then they can't produce it because they don't have it. Right?
Yeah.
I don't know. It's almost
Yeah.
like they don't
It's
they're
rare this
trying to project that they don't trust the jury commissioner's office.
but it's like this is the first court case with a jury. Do you know what I mean?
Yeah.
Do you know what I mean?
It's like
This is
they're setting the founding rules right here.
yeah, we're gonna reinvent this. Do you know what I mean? We're gonna
And they're
change it
bringing
all up.
Brady versus Maryland into
Yeah.
it. They're like there's no question that the defense has the authority and responsibility to investigate the prospective jurors. Well, nobody's stopping you. Go to the jury commissioner's office and say you want the list. Why are you forcing the prosecution to do that if they don't want that themselves? It just, I don't know. It just, welcome back, Nana. Yeah, the Bethy Boop says it's not a case they can defend. It's like
No.
they are grasping, they are grasping, they are grasping. Okay, the last one. What is this one? Because the judge already did make an order on this one. Notice. So, defense's 41 motion. Notice the defense will require additional time in which to file motions. Because, yeah, from what I've heard, they've got a ton more motions coming. Mr. Barry Morphew, through the undersigned counsel, notifies this court and counsel that the defense requires additional time to receive and review discovery, conduct an investigation, and research, write, and file appropriate motions. Mr. Morphew states, how many pages is this? 3. Mr. Morphew acknowledges that this court rescinded its requirement that all motions be filed by April 13th. In abundance of caution, defense counsel provides notice that Mr. Morphew's work is ongoing and the defense intends to file motions on a rolling basis as they become necessary, responding in a prompt manner to the developing discovery, investigation, and the government's filings. In a prompt manner, that's how you drop 32 motions on one day. Instead of as they came in, you could have filed them. No, you held them all and dumped them on the prosecution in one day. This notice is filed pursuant to the 6th, 8th, 14th Amendments to the United States Constitution. Mr. Morphew's constitutional right to have the prosecutor disclose exculpatory information in sufficient time for Mr. Morphew. This was at the very beginning. Like he's repeating stuff in his motions too.
Yeah.
To make meaningful use of it and the right to the effective assistance of counsel and to conduct a meaningful investigation. Wow. Mr. Morphew does not make any intentional or knowing waivers or forfeitures of the right to object or file additional motions. This court at some point denies a motion because it was not filed by the court's deadline. That will create prejudice from deficient performance by counsel or from prosecutorial misconduct or failure to make discovery. It should not be regarded as strategic or voluntary on Mr. Morphew's part. Ugh. Waiver may be explicit, such as when a party expressly abandons an existing right or privilege, or implied, such as when a party engages in conduct that manifests an intent to relinquish a right or privilege or acts inconsistently with its assertion. Oh, are you talking here about when you tried to have her cremated, but you had already filed a motion that you wanted rights to do your own testing? I haven't given up that right. And if we had cremated her, I did not give that right up to do that testing. It's just crazy. To find a waiver that is not expressed, the conduct upon which the implied waiver is based must be unequivocal, and it must clearly manifest an intent to relinquish the claim. Mr. Morphew still has more to say. Hold on to your drawers. Mr. Morphew disavows any intention to relinquish any claims. And in it, so he's not agreeing to anything that he said in the past that may, excuse me, that may have seemed or felt like that he was giving up some kind of right to whatever they are talking about at the time. An inability to get any particular motion done by the deadline in the face of Mr. Morphew's disavowal of any intent to waive cannot be regarded as an unequivocal waiver, which means even if you think that that's what he was doing, that's not what he's doing. Huh. Well, nothing like playing with words. Mr. Morphew provides this notice and all other motions and objections in this case, whether or not specifically noted at the time of making the motion or objection, as a continuing objection based upon, in addition to the above authority, the following grounds and authorities. So it's going to be an ongoing objection. So anytime you bring this up, once you've made your ruling, anytime this is brought up, we're going to object in court or out of court, basically is what he's saying. In abundance of caution, to ensure sufficient time to review and respond to discovery and continue investigations that are still outstanding, Mr. Morphew acknowledges this court's revision of the motion's deadline and disavows any knowing waivers. So they're saying that they don't agree to it and they don't admit to it. What did the judge say? Motion, let me make this a little bigger. Notice the defense will require additional time. So the motion, so the D41, this is the judge's order attached here to granted in part.
Wow.
So we don't know what part he agreed to and what part he didn't. Any additional motions the defendant wishes me to hear July 6th through 11th. Okay, so it's not the 7th, it's July 6th to the 11th. They're hearing all these motions. And don't forget, not only the defense's motions, if the prosecution has any motions, this is the time that the judge is going to hear motions from both sides, the 6th to the 11th. And so far, there was 34 minus 3. So, almost 30 motions alone so far, and there's more coming that are just from the defense.
Yeah.
I haven't seen any motions yet from the prosecution. I haven't even seen the responses yet. So any additional motions the defendant wishes me to hear from July 6th to the 11th shall be filed no later than 4:30 p.m. May 29th. Ooh, which is this Friday. Responses shall be filed no later than 4:30 p.m. on June 22nd. So any responses that the prosecution is going to make, and then any responses that the defense is going to make to the prosecution's response, all those responses have to be in by June 22nd. No replies to the responses to the additional motions will be. Oh! So, there we go. The judge, I think, has caught on a little bit to what the defense is doing here. So remember what I just said?
Yeah.
That once the defense files a motion, the prosecution files a response to that motion. And then usually the defense files a response to the prosecution's response. The judge is saying, nope, not here. No replies to the responses to the additional motions will be considered.
Wow. Good.
Good.
Because they look like they're playing for time, isn't it? But Barry wants to stay as free as possible, as long as possible.
Well, they're trying to bombard the prosecution, and I mean, they're trying to bury them so far in paperwork that they're hoping that they miss something that they can pounce on later. You know what I mean? If they got all this stuff being thrown at them and the
Yeah,
prosecution's
might
trying
be
to
something.
respond to it all, now you want us to go back to all the law enforcement agencies and every sheriff and deputy and FBI agent we talk to see if we missed something. We got to do that on top of responding to your motions. Let me check and see if there's been anything else filed. I checked this morning and didn't see anything, but let's see.
If I remember rightly, there was an issue with the terabytes of data, and they couldn't access it with the
That was in the first trial, not this
yeah.
one.
Oh, I know what I'm saying, but who's you have to take their word on it. Do you know what I mean?
Yeah.
Like,
And Taylor tried the same thing too. Oh, you send it to us in a form that
yeah.
our technicians can, well, get new technicians. You know
I,
what I
I
mean?
wish, I
Like,
wish, I wish Barry had to write these motions himself. It would be brilliant. Hey,
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 my
yeah.
my name's what
Wanna,
the hell?
wanna, wanna
My
look at
name.
this?
Yeah.
What you think?
What you think about that? Cash me outside.
3 words to every sentence. Huh?
Yeah. Oh God. Okay, so no, the last stuff that was filed was the last one that we just read. So there's been 41 messages. Oh my God, Willow, get your shit together. Motions, messages. 41 motions filed so far, and they said they
Wow.
got more coming. So out of the 41, so they got 38 motions right now to be heard between July 6th and the 11th. And that 6th to 11th days are set aside for both prosecution and defense. Is defense trying to file so many motions that the prosecution doesn't have any time for theirs? I don't know.
I know that. 100%. They will have extra staff on, but that was half of Linda's problem, is that she had a small office with 2 or 3 people working in there, and she wasn't working herself really,
Hmm.
you know. So they were swamped.
I'm still waiting for the rest of the third batch of information to come out in the Brian Kohlberger case. I keep checking that every day, and they've changed their format here, which is good because now everything's a PDF, so which is good for me. I know how to do PDF. You
Yeah.
giving me all these other type files, I have to search online and figure out which program to use to open it. I wonder why the lawyers can't do that. If I
Mm,
can do it, one who screws up everything, if I can figure out how to open a certain type of file, I'm sure that their technicians can. If not, I want to go work for them because I can Google shit. Okay, Blitz says the master of confusion and chaos is what it is. Yeah. Not only that, they're trying to bury the
mm,
prosecution.
that's right, Barry. The best man for burying is on the case, Barry.
Barry.
Speaking of
There we go.
Barry burying, why do you think Barry would have only buried her in a foot of soil and in a
I
place which was frequented by hunters, and you had Carl Colby um, living sleeping in the trailer. And
my on
I wonder where the tip came for when they were searching for Edwina at that time,
mhm.
Quintana. I wonder was it an anonymous tip that there that she might be
or
buried there.
or was it somebody that Barry got, or did Barry somehow?
Yeah, I'd say it was either, yeah, maybe somebody like that, or I'd say probably anonymous. Do you know what I mean? I don't want to,
Hmm.
but have a look down there. That's where Edwina may be. Do you know what I mean?
Well, I know they were searching for that older lady that had gone missing.
That's
I
what I'm talking about, Edwina
Right,
Quintana.
but okay, let me just do this. Hang on. Colorado, because I okay, hang on.
Because
Okay,
if you
so here's the key details. The remains were found off Highway 17 near mile marker 103, roughly 45 to 50 miles south of the Morphew family home in Salida. The site, investigators found her skeletal remains in an area of brush described as undeveloped rural field and utility easement near the town of Moffat. It was not a populated residential area. Um,
she wasn't down that far, she was near the telegraph poles.
right. Colorado Bureau of Investigation discovered the grave by accident while searching the region for another. Okay, let me get this. Hang on.
Right.
Because that's not the question I asked. Let's see if this will give it.
Well, the other thing is
Ah.
if you had just bones, right,
Mm-hmm.
and that's all basically that they're saying was buried in that grave was just bones, because there was no decay, there was no decomp, there was no decomp on the clothes. It was all just placed in there. And if you had her buried somebody somewhere else, and you had to dig her up because she was too close to Puma Path or whatever, you know what I mean? Why wouldn't he just put the bones into a sack and crush them with a rock or a hammer or something like that and just drop them in a river? Wash, did wash away.
Right.
He wanted those bones to be found with the clothing. It's all part of
Well,
the
he messed up because he threw the clothing in on top, and the clothing had no decomp on him either.
yeah, and wasn't the bones weren't inside the clothing.
No,
Do you
the
know what I mean?
clothing was on
Like,
top of the bones.
yeah, or on top or underneath, I don't know, but there was a pink glove in there, work person's glove. There was a balaclava. There was uh, what else was in there? There was something else, I think, but there was those two things anyway. But these are all stuff that was planted to go along with his narrative. Do you know what I mean? That she was
Okay,
snatched and
right. But okay, look at this. Is I knew I had seen it somewhere. The area where Suzanne Morphew's remains were discovered is entirely desolate, open country, free of any residential structures or trailers. The mention of the trailer in relation to this case case specifically connects to two entirely separate pieces of evidence. Okay, so the actual location where she was found, an area locally referred to as the Boneyard near Moffat, Colorado, is wide open, barren desert landscape filled with sagebrush,
yeah.
situated a few hundred feet off of Highway 17. There was no active homesteads, trailers, or residents in the immediate vicinity. So that's what I said. That trailer, I don't think that trailer was there when her remains were found. Now, there's photos on Google Earth that shows a trailer there. But when they
Yes,
found her remains, there was no trailer there.
right. But
There was nobody living in that trailer at that time, and
when
the
when
trailer wasn't
when
there.
did when did Edwina disappear? Do you remember
I'll find out right now.
Edwina Quintana?
Did hang on. What was her name?
Edwina Quintana, I think it's Quintana.
Lena Quint. Uh, bear with me here. Okay. Um, the missing woman authorities were searching for when they discovered Suzanne's remains was actually named Edna.
Oh, Edna. Right.
Edna Quintana, not
Edna. Right.
Edwina, and
Sorry.
she disappeared May 3rd, 2023. 3 years
So,
almost to the day after.
yeah, yes, that's right. I thought it was May 6th, actually. But and then Suzanne was found in September 23rd or something like that. Was
28.
25th or something? 28th, was it?
I think so.
Well, it might have been 28th. But I'm just wondering, was that trailer moved? But I remember hearing that Carl was living in that trailer.
No, see, when she was found, there was no trailer there.
No, no, no. I'm not saying that. I'm just saying that.
When she went missing, or when you think, like, when do you think he planted her there?
Oh, I would say
I think it was
probably,
after Edna went missing.
possibly, possibly.
Because if they're out there searching that area, because she went missing from the area, and he knew that they were going to be out there searching. Now, if he wanted her found,
Yes, would
you
make
know what I
sense,
mean?
wouldn't it? It would
Yep.
make sense.
And it
And
wouldn't be unusual for somebody to be out in the fields and everything, because I know people were out searching for Edna.
yeah, but not only that, like he's in the game. He could go there, dig a shallow grave, put back in the sage bush where it was. Do you understand
Mhm.
me?
Yeah.
And after a few weeks, you wouldn't know.
Right.
Do you know what I mean?
And that's why
But
I'm saying, like, did he really want her found?
I think he did. Yeah,
Do you
he did.
think that whatever he did to her remains to bleach her bones and all her hair be gone and everything, do you think he thought, yeah, because he left the, I said pacemaker before, but it's a
Port.
port.
Yeah, port.
Um, he left the port
Like
there.
he needed her
If
body
he
to be
didn't want,
found to get the money.
but he already got the money.
No, the guardianship.
Yeah, he
No,
got
the
the
insurance.
guardianship over selling the insurance money.
Yeah, because
But
she wasn't.
but the thing is, did he really think that whatever he did to Suzanne's body was going to take care of any trace of the BAM in her bones?
I'd say he had no idea. Like
I don't think he
he's
did.
clever. He's a clever dude, but he's not that. He's not that type of clever. Do you know what I mean?
Right.
Like
I'd like to know if
he's clever
did they
as
find
a
her
hunter.
teeth?
Hmm?
Did they find her teeth?
I don't know.
I don't remember. Okay, let's ask.
I don't remember Alex mentioning it, actually.
Uh, uh, let's see.
And
Yeah.
if they had the teeth, yeah.
It says when investigators from the CBI discovered her shallow grave, coroner used her dental records alongside a medical device, her cancer report, to positively identify her skeletal remains. And then it said, according to the official autopsy report, 3 teeth were explicitly recovered from the site and released to CBI for
Oh,
DNA testing. 3 teeth.
mm.
Because of the majority of her bones were recovered but significantly bleached from exposure. From exposure.
Where does this?
Forensic.
Hold on. Where does it say that? Where are you getting that from?
I'm getting this from AI.
All right. Because
So, yeah, some
it
of it you
doesn't
can
say
take
that.
it.
It doesn't actually say that in the indictment.
Right.
It doesn't say exposure. Do you know what I mean?
But they did say her bones were bleached.
Oh yeah, it says a bone to bleach, but
So AI
that's why
is
that
just
adds on.
assuming,
But yeah,
assuming,
I
making
noticed
an
that with
ass out
AI.
of me and you.
Mm,
Exposure. Experts relied heavily on dental findings and the chemicals trapped inside her bone marrow to piece together how she died. The autopsy eventually proved her cause of death was homicide via animal tranquilizer cocktail known as BAM. So they got a lot of it right, but they never did say what bleached her bones.
no,
Hey,
and
Lisa.
I think that makes a big difference. You know.
Well, yeah, because I think it's going to tell us a lot about where her first
Yes.
place was.
Exactly. Hmm.
Um, I kind of got going on in my head. It's like which place, and it's got to be somebody that knows him well, that maybe has a shop or
Yeah,
something where
you can store
um,
something.
he knows that you know how people have barrels of oil and stuff like that? It has
Yeah,
to be
yeah,
disposed of a certain way. So it could sit there for months. Like a
yeah.
place like that where there was some kind of chemical that he knew had been just placed there and they wouldn't be disposing of it at anytime soon. And that stuff would do this to her bones.
Well, I reckon he left at 5 o'clock in the morning. We know that because he was clocked by the Shell gas station on the CCTV, and we know that he was clocked from the hotel at
Mhm.
um, at 7:34, but that was actually 8:34. So we know he was at the hotel around 8:26. That's when he arrived at 8:26. Um, we
So
used to
he
think,
would have had to put her body in something before a business opened that had some kind of chemical that would do that to her remains.
yeah, or well, look, just put it this way: if you're in a sealed container, maybe you would, you, and there was something to break down, some of the flesh or whatever. But if you look at the mileage, there's 20 miles difference between what Google say it took to get from Puma Pat to the hotel and what Barry took. There's
Mhm,
20 miles difference. And there's also 30 minutes missing.
mhm.
But the mileage from Salida to Bailey, where he stopped and he made a text message and he sent a phone call, I think, received the phone call or made a phone call to his mother or sent the text to Suzanne, maybe all around that time. But when he was at Bailey, he was on perfect time.
Mhm.
It was after he left Bailey is when the extra
So
it took
somewhere
a
between
half an hour
Bailey,
and the
I
hotel.
still say he was near Sand Creek too, where that place
Yeah,
where I'd gotten.
100%, 100%. I agree with you.
And
I
I mean,
100.
I think that's when I did the pendulum session with the mapping, and I got Sand Creek.
Yeah,
I got my, and then I had somebody in Colorado, from very near where Barry lived. I'm not going to even repeat her name now, but she went out there looking, and that's when the blue blanket and the cooler and all kinds
yeah,
of
yeah.
shit was found out there. And that's the exact area that I got with my pendulum.
So you imagine, like, if you're tidying up, why would you, like, he had loads of things to get rid of. We see
Hmm.
that from the bags he was carrying at the hotel.
Yep.
Like, there was a laptop. He got rid of it. There was no mention of this laptop. He had a laptop. It was, you can see it in one of the cameras. He has it kind of hidden. But there was a laptop that he got rid of. I think it was at the men's warehouse or somewhere like that because
Hmm.
that the timing of when he we seen it at the elevator. But there's no mention of this laptop in anywhere in the DAA or
Damn,
transcripts
I
or
wish they could have found that shit.
yeah. But see, some of it would have been innocent stuff. It was just he would have mixed it up a bit. You know what I mean?
Yeah.
It would just get rid of three
Throw
uh,
stuff with actual garbage and
exactly, and
pieces
every
in here and an old Smarties box. Well, there's the USB stick and
well,
whatever.
you see him bringing the stuff into the hotel.
Yep.
It's all in that.
And
It's
going to
all
the different bins and everything with bags of
so.
stuff and
Well, when he's going into the hotel room, it's all in a backpack or whatever. When
mhm,
he's coming out, it's in bags, and you can see it's wet. So
yeah.
he washed everything in bleach before it went into the trash.
Oh, absolutely. Luby Lou wants to know, Martin, do you think he will go down?
Do I think he? Yeah, 100%. He will go down on the Bam alone. But
The real Angel Girl says, is Barry getting a jury trial, not a bench trial? Yes, he's getting a jury trial. He's gone with a jury. Nana says a high percentage vinegar would work, but I don't think that
mm,
would melt all of her. Well, I mean,
time,
he could have
time.
rinsed off the bones. We don't know what he did. She
But
says
there was,
strong
there was,
vinegar will peel off skin. Now, we don't know what he put her in, but whatever it was, there's no hair, there's no tissue, there's no organs, there's no nothing. It's just bone,
and, and there's
teeth.
no animal um,
Yeah. No
gnawing.
animal marks on her bones, like gnawing
No,
marks or anything on her
no.
bones.
So this body was not left out in the wilderness.
No, no, it
This
was in
body was
something.
concealed. This body
Hmm.
was concealed either in a box or whatever, you know, a cooler or whatever, or a barrel, as you say, or maybe just a box and something else. We wouldn't know.
Mm,
But what I'm saying is, if you're heading, if you've got all this stuff, and I'm talking about you've got laptops, you've got the CCTV or recorder from the house.
hmm.
You've got books and financial stuff, or anything that is
The letters.
spam letters, yeah, anything that she's written that would have said something about the marriage, broken bits of furniture, stuff like that, all has to be
Hmm.
got rid of. Why wouldn't you just do it all at the same time? One trip, Suzanne and all the other stuff disposed of
Because you
on
don't
the
want all that stuff found together,
no, no. But I'm
right?
saying he made 6 trips that we know of, you know, to different places. But I'm saying he probably could have made a few more. Like he stopped at Bailey because stuff was flying out the back of his truck, as he said.
Yeah.
Um, he had to straighten it up and blah blah because the wind was blowing stuff out the back of his truck. So he could have been get rid of stuff at Bailey. Do you know what I mean?
Yeah.
And
And
but
anywhere in between in the mountains and he
well,
could have
he
got
only
rid of
had
stuff anywhere.
it's only 20 miles, right? There's only 20 miles that he could have detoured. So
Hmm.
that could mean going 15 miles out some track and 5 miles back in and picking up the road and not losing, only losing 15 or 20 miles in total. Do you understand me?
Right. 10 miles
So,
out, 10 miles back.
yeah, if you're going 10 miles out and 10 miles back onto the same spot onto
Right
the,
to the same spot. Yeah.
yeah, that's basically what he did, right?
And that's
And,
why I said that's where the Sand Creek that I
well, I tell you
pinpointed,
now,
that's where I think that comes in.
well, I tell you now, um, Willow, I'm nearly 100% sure that further um, uh, up the creek, as we'd say,
Hmm.
Sand Creek River, if you follow it up and it comes into something else, uh, another creek it's called, I can't think of it now, but right up there is where Barry's phone pinged, right? Like
Hmm.
we know it pinged over. It was in his locations. Let's put it that way. It was his phone locations, and but we know
His phone pinged near the location that I got on the maps.
a little bit north, near Commerce.
So damn near
Com-
close.
I'm talking probably about 5 miles, 6 miles,
Because that's
uh,
where the cooler, the blue
or
blanket, and that blue blanket, I got pictures of that blue blanket. One of the daughters, I think it's Macy, has it wrapped around her in the living
Christmas.
room at Puma Path.
Yeah, well,
It's the
Barry's leaving
exact same
behind.
blanket.
Yeah, he's
Because
lucky.
people at first thought, "Oh, look at that looks like it's got bleach stains on it." No, it was
Yes.
white. It was a blue blanket, blue fuzzy blanket, and the white parts on it were actually white imprints of deer or something. It was some kind of animal print all over it
No,
in white
no.
fuzzy
I
material.
I seen that blanket on.
Macy had it wrapped around her when she's
Yeah,
sitting in
yeah.
the chair in front of the fireplace.
But that blanket was there after about a year afterwards, maybe. Um, you can see it on the Google Streets view.
Oh, can you?
Yeah, so if you go over the bridge, you know that bridge
Yeah,
in
that
Stanley
little
Park,
bridge, yeah.
you can see the blanket down below.
And the cooler was not far from the blanket.
But no, but what I'm saying is upstream. If you go upstream, just think about it. That cooler was found in end of August, early September, right?
Hmm.
So, but Barry was going to Broomfield. He put that cooler and maybe a container, a box, or whatever it might have been in, into storage, right? Into either a storage wagon or a trailer or a unit, but
Hmm.
outside. You know what I mean? Not inside, an outside one. And there's ones there. And right beside where this storage place is, there's a river, a creek. And that creek runs into Sand Creek, which runs down to Sand Creek Park, where the cooler and the
And don't
suitcase
forget, we
and
also found that suitcase that they couldn't get out of the water, and somebody blabbed it out to everybody. And the next day, when they went back with the canoe to go get it, the suitcase had been emptied because it was left open.
yeah, well, that could be part of it as well. But it just the cooler. Everyone was talking about a cooler, and in most of these cases, it's a suitcase or a cooler. Do you know what I
Hmm.
mean? And I'm
Both were found at that area with the blanket.
what
It
I'm
seemed
saying
very
is
suspect.
I don't believe that it was dumped on May 10th.
Oh no, no,
I
no,
believe it
no!
was dumped.
He had to
He
uh,
went back to this place wherever it was stayed in storage, and
right
he
wherever
would have
he put
to.
her in, whatever he put her in to get rid of all the skin and everything.
Yeah. Well, he would have
From
had to
there
be
is when he went and
dumped.
dumped. Yeah.
Yeah. And he probably put something in that cooler so that it would sink. And
Oh,
he probably had the
probably.
blanket in there. He had the little bit of tarp in there. There could have been other things in there.
Yeah.
And he threw it in there hoping it would sink. And it didn't. It just tumbled over because it's full of polystyrene. And it just floated off. And he just said, hell with it. You know what I mean?
Correct. But with the suitcase was only seen, it was weighted down, like it was heavy. They tried everything. They tried to
Still,
hook it and everything to pull it out. It was too heavy. And
yeah.
the only reason that suitcase was even seen is because of the drought that happened, and that
Yeah.
river went right down. It dropped like 3 feet or
That's right.
something.
But
That's
it's
the
only a
only
trickle.
reason, because that suitcase never would have been seen otherwise. It
I
was
seen a
three
picture
feet
of it.
below mucky water. Yeah. Anyway, they couldn't get it. They couldn't get it. They couldn't even budge it. It was that heavy. And I said, don't say nothing to nobody. And I think you know who I'm talking about. One person opened their big mouth and
Yeah.
started blaring it out everywhere. Well, the next day, when the person that I had going there and checking on things that found all this shit When she went back the next day with her son and a canoe to go and get the suitcase was opened and nothing was in it, and it was light as could
Yeah.
be.
There's fish in it.
It had been zippered up and everything, so there's no
No,
way
but I mean,
fish could have got in it.
there was fish in it. I seen them.
Oh, maybe when they pulled it out,
She had a photograph of it,
but when she
and
first
saw fish
found
in it.
it was closed. It was zipped
Was
closed.
it? Yeah.
The next day when they went back and finally was able to get to it, that's when they seen somebody had already opened it.
But
And there,
well, this all makes sense. Like that I know when Barry left to go to Broomfield, and it took him 3 hours and 3 hours and 30 minutes. Was it 3 hours 30 minutes to get to 3 hours and 24 minutes to get to Broomfield? And his return journey, and that was 181 miles he drove, and his return journey was 167 miles, and that took him 1 hour, sorry, 2 hours and uh, 35 minutes,
hmm,
right?
a lot different than him going out.
Yeah, a lot
Okay,
different.
Luby Lou wants to know, do you think George is involved?
I don't actually.
Yeah, I didn't. I
I don't.
At first I was iffy on George, but
Like he'd
no,
be like I'd say he's one of these guys he'd look out for Barry, you know what I mean? But I don't think
he's not
he's
going to go
he,
down for him.
no, I don't think he's done anything
And I don't think
wrong
he
wrong.
would be involved in anything criminal like that where he could spend the rest of his life in jail.
Yeah, I don't think he was helpful to the police, but he did say on the night he was there, he did say it looked like it was a setup. Do you know what I mean the bike was a
Yeah.
setup? He did say
Okay.
that.
And did you notice that the defense filed motions saying that they don't want any kind of talk that it was a setup or it looked like he set something up or it looked like he was guilty or he acted like he was guilty? I
Yeah,
think they
no,
may have subpoenaed George. Was
maybe.
George on the prosecution's
Yeah,
witness
yeah.
list?
Mm,
There you go. They're trying to cover their tracks, not only with Macy and what Macy said to her mom about getting a protection order and divorce and all that shit.
yeah.
Now, George, you know,
Somebody asked me about that today on Reddit, and I sent them over a big long list of stuff that Macy said.
mm,
Um, uh, just you know, they were asking me the same question you said there now about Macy and would
well,
she be on
that's in
stand?
the documents. We've already seen the text
Oh, I know.
messages where Macy says, "Mom, just get a protection
Come
order, get a restraining order, and we'll move to Salida and
on, get a job.
get a job, and you can get a divorce. Me and you can
Yeah,
live in an apartment, whatever." Like those text messages are there; they can't be erased.
and there's the text message that Macy sent to Miles. Do you know what I
Hmm.
mean? And there's her interview. She done an interview when
Yeah,
she on the 11th, and that interview she told them that the marriage was uh, it was in a
toxic.
toxic and it was unhealthy.
Yep.
Do you know what I mean?
Yep.
There's you
And
know
now she's saying something totally different.
I know, but you can't do that. You can't go back.
Well,
Even when
no,
it's
but this is what I mean is the defense is doing everything that they can possibly do to keep Macy off the stand and probably George.
yeah,
Like that's why they're putting out all these motions like, okay, we don't want anybody being able to say, oh, he looked guilty, he acted guilty, he said something that made him look guilty, or, it looked like he set something up. It looked like he did that. They don't want any of that. They don't want any of Suzanne's statements to anybody, including Macy, her best friend, anybody, where she
well,
discusses Barry.
I tell you, Miles Harvey would be able to tell a lot without hearsay because he was in the home. Do you know what I
Hmm.
mean? He was like part
Yeah.
of the family, as was Macy
He knew
part
a
of
lot, and
the.
Macy shared a lot with him.
Yeah, but he would have seen it himself anyway.
And
But
did you
this,
notice it's not long after all this that they broke up? It's like you got to get the frig away from that guy, stay as far away
Yeah,
from
yeah.
him as you
Oh God.
can.
Well, he was talking. You see, he was doing his due
Yeah,
diligence, and that was it.
yeah,
So not only did Macy lose her mother, she lost her best friend, her boyfriend,
yeah,
and all her family,
yeah,
all his family. Do you know what
yeah.
I mean? All the Harveys, because she was living with them as well.
Hmm.
Like, you know what I mean?
Well,
But
stayed there a lot. I don't think she was actually living there, but she stayed there quite a bit.
well, yeah, she stayed there quite a bit and probably
Yes,
stayed over.
Miles is on the witness list. Yes.
So this is what Macy said on May 11th. She admitted that her parents argued a lot, and she feared that they would separate or divorce. She said that they were not doing well, and that it was for the best that they would separate. Macy reported that they, Barry and Suzanne, were both in an unsafe place emotionally, and this was on May 11th,
Hmm.
the day after. Like,
And she's tried to redact all that too, on top of the text messages that they found between
oh yeah,
Macy and her mom, where they said, "Mom, just get a restraining order," blah blah blah. On top of all that, on
yeah,
top of what she told her friend, she told Macy she was terrified to be alone with him.
yeah,
She told her friends that. I'm sure she told her parents that. Rest their souls too. Like they know that there's so much there that they can't get around, that they have to resort to motions like this that they're making. And then especially to say, like Barry already muted her. And
yeah,
now you don't want us to be able to use anything that Suzanne text,
yeah,
recorded, phone conversations, people that she talked to about how unsafe she felt, and everything that she talked to them about. You want to try and mute her in death too? Pfft.
yeah. And mm, like you know, Holly, not Holly Booton now. Um, her friend Holly Wilson.
One from Salada.
No, no, not that. Edifka. She's from Indiana, but she was a good friend of Suzanne's as well, and she recorded Barry secretly. Do you
Oh
remember that?
yeah, I remember something about that. Holy Christ, we got how many years ago? 6 years ago this happened,
Mm.
and
So
it's
she
like,
recorded Barry, and it was very interesting because when she quizzed him about what happened on Friday night, his face distorted, and she kept pushing. She said, like, there's no way that Suzanne would have sent those Facebook
friend
requests.
requests. Yeah.
And Barry says, yeah, it's not like her. She'd never done that before. And then she kept pushing and pushing. And she said, what was the last thing she ever said to you? And kept pushing. And he then got really angry and he said that she was leaving me, that she was leaving Barry. You know what I mean? But also,
The
a week
last thing
before
that
that,
she said to him, and that is also she sent it in a text too to him.
the last thing that who?
The la- was that the last thing that she said, because that was sent in a text too. I'm done. I just want to end this amicably.
No, that wasn't the last
Remember?
thing. Yeah, I remember that
But
text.
no, when the friend asked Barry, what was the last thing she said to you? Oh, she wanted to leave me. Well,
Yes,
because we did see texts where she said, I want out,
yes.
basically.
But you see,
But
Barry
then what
said,
happened after that, Barry? You lose your shit?
"Oh, we lost it." Like this was this. The whole thing started a week before Friday. The Friday
Mhm.
before, Barry was away. Suzanne was celebrating her birthday a day after. It's actually May 1st. She was celebrating her birthday on May 1st, and with Laura and Andrew Richardson. And Laura spoke about how Suzanne was in great form and whatever that. She was talking about
Yeah,
future,
it's a good
her
shape.
future. She was in good
Well,
shape,
didn't wasn't
healthy, and
wasn't
she
that conversation too where she had beat the cancer again?
She was doing well, I think. I think she said that
She
she
had
was
beat
doing
it.
well.
Well, she went into remission again. And Barry was expecting this time that it was going to kill her. And it didn't. She went into remission again.
But no, this was just a week before she
Right.
disappeared. And she said that she spoke about doing the books for Barry and how it would be a bridge between them, a bridge between Suzanne and Barry for Suzanne to do the books.
Mhm.
She was openly discussing leaving
Right.
a week before on our celebrating her birthday, and I would imagine Macy was there. I'm not
Mhm.
sure if Mallory. I would have thought Mallory was there
Mallory was in Gunnison, I think,
on the day of her birthday.
the Friday before. I think she was in Gunnison.
Maybe she was, but at least Macy was there, and there was other people. If that had got back to Barry, right,
Mm.
and then the wheels go in motion with they started off on May 4th, or sorry,
The
yeah,
wheels
May
go in
4th.
motion, and a trip is
Yeah,
planned that the girls are going to be
there's,
gone.
there's a on May 4th. There's like about 5 or 6 calls and texts or whatever, right? And then next thing we know, Macy's going to Gunnison to go off with Mallory on the road trip.
And Barry's
And
sister.
then on May 6th, we have the big argument, I'm done. And then
Hmm.
Barry's suicidal
Yeah.
replies and all that. May 7th was quiet, the calm before the storm.
Yeah, but
And
didn't
then,
he leave that night and he went somewhere else? She didn't know where he went?
no, he went to George Davis's gym.
Okay.
And after the gym, I'd say he was. They weren't sharing the same room. He was in a different room in the house, like.
Mm.
And the next morning, when he went to work, is when she saved her list of grievances in the cloud, and that's a big thing. She wrote
Hmm.
this 60 lines of grievances, which are directed directly to Barry. You know what I
To
mean?
Barry. Yeah.
And then that happened. Then the next thing that happened was she texted him, "Oh, I forgot about Rob. Sorry, I forgot about Rob Azell last night to do the invoicing, but I will continue to do your invoicing if and when you need me to." Saying, "I'm leaving you, but
Yeah.
I will be civil and I will do your stuff." The next very thing after that, she texts a conversation with her sister Melinda, who had no idea that Barry was being abusive physically and
Yeah.
mentally towards her. He knew they had problems, but he never knew. She never knew anything about
She didn't
the
know how bad it was.
and she had no idea why Suzanne was texting her that there and then. After that,
She
Suzanne rings
texted that. I
Barry.
think she texted that because she was scared to death that something was going to happen and nobody would know.
Yeah. Oh yeah. Then Suzanne then rings Barry at 10 o'clock. Barry's on his bobcat, and Barry then she hangs up, and then next thing Barry rings and texts her constantly for about 5 or 7 minutes,
Mm.
like a lunatic, like he did
Yeah.
on May 6th, and he did on May 4th.
So whatever she said to him pissed him off, and she hung up on him,
Yeah,
and
he
he
hung
was
up on him,
pissed.
and eventually at 9 minutes past 10, she rang Barry. And the phone conversation went on for 26 minutes and 34 seconds, 37 seconds. And I tell you now, that was probably the longest conversation they had. Now, mind a phone call. And
Mm.
and I can tell you now that that was Suzanne telling him, this
Yeah.
is it, final.
Yeah.
And then
We're done.
after that, about 15 minutes after that, he sends her a text saying, I love you, Suzanne, right? At 5 to 11. A half an hour later, Barry goes missing from his work site, and he drives somewhere for about 20 odd miles.
Mm.
And
That
he
20 miles is coming into play again.
and he's missing for nearly an hour and a half. And he goes home and he takes care of business. He
Yeah.
has her injected, and she's all tied up or whatever like that, bound or whatever. And he goes back to work as if nothing happened. He has a phone now, and he carries on like he makes phone calls as he's leaving the site. He goes back to the site, loads up his bobcat, goes to the next site, and on the journey, he makes 6 phone calls. One of them is from Suzanne's phone to his phone. And then after he finishes work, he phone just before he finishes work, he phones again from Suzanne's phone. But on his Bobcat, we can see a minute before the phone call happens, Barry goes shuts his his Bobcat down.
Mm-hmm.
So you can see all the whole day. If you look at his Bobcat, you can see what Barry's doing. All these phone calls that are going on, Barry stops his Bobcat,
Yeah.
calls, phone calls, everything. So you can tell what's happening,
Yeah.
and you can actually see. You can't see the first one because he's driving between one site and the next site. But that call that he made to Suzanne, he goes into um, idle just a minute before that phone call's made.
Mm. Well, I remember when I seen your guys mapping out of all of this, and it was like, holy shit.
Maybe from say again.
Every little move that that bobcat made, and when you guys
Well,
thought that he, like at the time that he removed stuff so it wouldn't have the GPS and then put it back, and oh my god, no, they're all talking in the chat about it, and it's like,
well,
yeah,
well, I
Martin
tell
and
you too.
Kurt knew the stuff about the GPS, like they had every single movement that he was doing.
But we didn't know everything, right? So one thing we didn't know was that the phone calls on the phone call log list was altered.
Hmm.
We had no idea. We took it as gospel. It was data. We took it
Well,
as
it was
gospel.
Iris Eaton that did that.
Well, we don't know. We don't know. Was it Iris Eaton
uh,
that did it? We don't know. Was it Barry's truck that did it? Barry could have interfered with his truck, and it could have caused a 1 hour and 1 minute discrepancy. So what we thought, we thought we had the phone calls from the truck, and then we had 30 extractions. So we thought we had 90 calls for the phone calls, and then we had 30 calls. So we thought we had 120 calls
hmm.
because they didn't all match up, but some of them did to
Yeah.
within a few seconds. So then we realized these extractions were of the same calls. And
Ah.
it wasn't until about 2 years ago that I realized that some something hooky's gone on here.
Yeah, somebody's messed with something. Whether
Like
it was Iris or Barry, one of them messed with something.
like you can't get away from it. Like the calls and the call logs are UTC minus 6 hours,
Yeah.
but they're not. Some of them are minus UTC.
Some of them are -4, aren't they?
No, no, no.
With the time change or something,
No,
wasn't there?
there's two at -7. There's two at -7, which is MST, which is Mountain Standard Time. But the other ones are Mountain Daylight Time, MDT.
Okay.
Is what we're in MDT now in Salida. If you're in Salida, it's MDT. So, but that's what all the calls should be MDT, apart from those two that are MST.
Mhm.
And the problem is that, and there'd be a couple of seconds between one naught and 10 or 11 seconds. You could have a variation, slight variation. But the thing is, all these calls, there's over, I think there's 16 of them, or yeah, 18 or 16 of them, that are 1 minute. They're like MST, the Mountain Standard Time, but there's an extra minute. So they're 1 hour and 1 minute exactly. And things like that don't happen.
Yeah.
1 hour and 1 minute more. You know what I mean? So it's like
Right.
there's 7 hours, -7 hours instead of -6. And
Hmm.
that's hooky.
Yeah. Something
So
fishy going
that
on
that
there.
threw us off. But when I realized it only a while back, and then I changed all my phone calls, my Bible, as I call it, and then when I matched it in with the data from the Bobcat, it read like a book.
Hmm.
Everything that was going on, even the phone call, even the text conversation that was going on between Suzanne and Melinda, Barry was idle for nearly all of that conversation. And you can see that Barry,
Ah.
so Barry was watching the conversation. So
Yeah.
he had a way of seeing whatever Suzanne was texting on
Suzanne
her
was
phone.
doing on her
Yeah,
phone, like a mirror on
100%.
her phone.
But you can also see that Barry, when he got to the work site in the morning, he was working like a beaver around as normal. And as soon as something happened, it was like Barry done no work. As soon as that 10 o'clock call went in, Barry ceased. He done like 5,800 kilometer, or not kilometers, meters. And then only for say 3 hours. And then for the following um, hour and a half, he done 200 kilometers.
Hmm.
Nothing. He'd done nothing. You could
Wow.
see him. He basically drove from one place to another and just was moving in the middle of the road, doing nothing.
Yeah.
And that's just before he went off to Puma Path.
Mm. Interesting. But we're gonna have to wrap it up, you guys. We've been here for a couple hours, and I'm getting antsy here. I can't sit much longer. I've been sitting and standing, sitting and standing. My back is just aching. My head's pounding. So we're gonna wrap it up. But Martin, I just love it when you pop in. Like some of the stuff that I seen between you and Kurt, what you guys did is just phenomenal. I was
We put a
hoping that
lot.
he did pop in the last live at the end, but I think I'd already shut the live down, ended the stream, and I realized he was in, or I would have said hi. But he did pop in on the last one. Um, but I'm always happy to have you. And if anything else comes out, I'll shoot you a message over on
Do.
X, and
For some
we
reason, I
can.
did, it used to come up into my email, and I don't be on X, to be honest, hardly at all. So I just happened to see your show had started.
Ah,
That's got on in my YouTube. So
ah,
unless I go into my X, I don't see them. I don't get the messages for some reason.
oh, that's weird.
I'm just looking at the chat here. A lot of old friends in the chat that I haven't seen in a long time.
Daniel. Daniel
Daniel,
Donovan says, "Can I call Barry a POS liar, cheater,
yeah,
murderer on this channel?" You sure can. Just try to mask the red drum.
yeah.
The red drum.
Do you know myself and Daniel? He will laugh now when I tell you this. But when Barry was arrested, Daniel was in Salida, and I was on FaceTiming with Daniel, and he's a lunatic. He's a great guy, and but he was walking up to that job site where the beach was,
Uh
and
huh.
the bobcat was there, and he's walking up, and I said, Daniel, get the bloody hell out of here! Don't go in there. That guy could bloody shoot you. And then, uh, oh god, it was so funny. And the next thing, I call and I see it come up on my screen that Barry was arrested, and I'm trying to get hold of Daniel. Then and I said, Daniel. Next thing, he's down at the courthouse. He was probably one of the first ones there. Uh, but he went to Tailman's, and if he pulled up beside Barry. Barry was on his bobcat, and Daniel said, "Hey, is that the bobcat?" And Barry says, "What?" And he says, "Is that the bobcat you murdered your wife with?" Yes.
Oh no.
Oh God. Crazy.
Well, Daniel just said Daniel Donovan will be at the trial. I live in Colorado and
He
cannot
does, yeah.
wait.
Oh,
Yeah. Well, Daniel, you're gonna have to add me over on X there and keep in touch. And we don't know if we're gonna be able to live stream the trial yet. The judge hasn't decided on what she's gonna do to alter that because now
new rules.
Colorado passed a law that says
Yeah.
you gotta allow streaming. So, but I do have to wrap this up, you guys.
Yes.
I am
Thanks,
just
folks.
like not doing good right now. But yes, we will get together again. I'll let you guys know. Keep an eye on my community posts, either here or over on X, and I will let you guys know when more information comes out. And if Martin wants to join, he's always more than welcome. We love having him here, and we will go over whatever else is being put into the record so we can stay up to date. So when trial comes, we're ready, we're prepared. So thank you, Martin, so much for being
Well,
here. I appreciate it.
thanks,
And
folks.
yes, thank you, everybody. Everybody in chat is thanking you for being here, Martin. They
Yeah.
all love a little Martin. Okay,
Uh,
guys. Until next time, we'll end it like we always do. Please take care of yourselves. Please stay safe.
yeah.
Always be aware of your surroundings. I love you guys to the moon and back.
Yeah.
Bye
God
bye.
bless. Yeah.